I believe that those charges are coming because, of course, how are marketers paid and how are people paid for leads, right?
We're really getting into some new novel investigations and prosecutions by the Department of Justice, by the feds. When it comes to the at-home kits, we're seeing not a lot of regulation.
And when you say the government is moving aggressively, I've seen search warrants being executed. I have seen bank accounts frozen, individuals arrested, or at least receiving target letters.
Hey everyone, welcome to The Federal Verdict. I'm David Tarras.
And I'm Marissel Descalzo.
And what we're going to be talking about on this podcast is everything white-collar defense, enforcement, prosecution, investigations, and everything in between. So,
welcome.
Welcome.
Today's episode is going to cover the COVID-19 pandemic and the current investigations related to that.
Yeah.
So, David, do you want to tell us why we're talking about COVID-19?
Yeah. I mean, we've talked about COVID in a million ways over the past 3 years, right? And now we're really getting into some new novel investigations and prosecutions by the Department of Justice, by the feds, and we're getting calls from clients, concerned, of course, and rightfully so, about, do I have liability? What's going on here? Help me. And yeah.
I've been getting those same calls, and I think a year ago those calls were about PPP loans, and now today they're about COVID testing. It's COVID testing, the PCRs, the rapids, and the at-home test kits. Are you getting the same kind of calls?
I am. Yeah, it's popping up. It's big.
And what kind of investigations are your clients being subjected to?
So the majority of the investigations that I've seen relates to the sale and the billing of at-home tests. And I know in our conversations that you've also seen another primary area that maybe started a little bit before because of the prevalence of the need for testing, rapid testing sites. And so I'd like you to talk about that a little bit when we're talking about lab sites versus at-home tests. Are you kind of seeing a distinction between the two and seeing those as the primary areas?
I am. And you said labs. I think labs are always a source of government enforcement because, so many things that labs can do that the government doesn't like. And, it was genetic testing just yesterday. And then today, it's these PCR and rapid tests. And I'm starting to see investigations centered around labs that processed test kits and the collection sites. But I have also seen some investigations, a couple, about revolving around the at-home test that the government agreed to pay for and allowed I think Medicare recipient was able to apply for, a handful of these test kits. And it was a short-term program that already ended. But I find that the government has quickly responded faster than other times with enforcement. Have you seen that as well?
Absolutely, I have. And I think part of the reason I'm seeing for that is when it comes to the at-home kits, we're seeing not a lot of regulation. And we are seeing certain individuals, including our clients, that may have not believed that they were violating any law, but that did see an opportunity to increase and ramp up their distribution of at-home testing kits to certain individuals. And when you do it with certain individuals like Medicare beneficiaries, then that's when the feds start jumping all over it.
Right. And to be clear, it's Medicare and Medicaid beneficiaries. Mm-hmm. I have seen both. And I believe that the government, and I don't know if you agree, that the government is identifying these individuals because the government has access to so much data. And CMS can press a button and figure out who has billed for the most at-home test kits, with the press of a finger. And I think that they're hitting those people first, whoever are the outliers and have the big numbers.
Yep, absolutely.
What kind of action is the government taking against these individuals?
So they're moving, in my experience, I think in our experience, they're moving very quickly. It is one of the I would say right now in the COVID-19 Department of Justice investigation realm, one of at least what they believe to be an easier to prove and easier to act on. One of the reasons you mentioned is because this data, the number of kits that are being sold, a lab might have been doing 100 one month, and then all of a sudden they're doing thousands soon after. You're also getting an incredible amount of complaints on a daily basis. These at-home testing kits, you're getting complaints to HHS, to OIG on the hotline, direct call-ins, and other various methods saying, I didn't order this. And when someone didn't order something, I think that kind of goes to the heart of why they feel that they can move quickly on these and aggressively on these in that situation.
And when you say the government is moving aggressively, I've seen search warrants being executed. I have seen bank accounts frozen, individuals arrested, or at least receiving target letters, which we talk about in some of our other episodes. Are you seeing kind of the same enforcement action?
Yeah, absolutely. Absolutely.
And who are the different players that are being targeted by the government in these cases?
Sure. So I think in our main primary categories of the clients that are coming to us and that we're seeing that are targeted, we have the lab themselves, we have the marketer slash consultant, and we can explain a bit more, right, and talk about what that is. And then also this sort of novel concept of data brokers or data miners who are specifically targeting Medicare beneficiary information. And that's when things move into an entirely new realm that they're acting on a lot as well, especially in South Florida.
And when you say data brokers, I'm going to just simplify it for our audience. I'm assuming you mean those individuals that are selling the Medicaid number, the Medicare number with the patient name and the date of birth. Is that right?
Correct.
And what charges is the government bringing against these individuals?
Sure. So in the general area, we have the anti-kickback that we'll talk about in a bit, but we have this somewhat new law as well. So in 2015, Congress enacted a new statute, a new code known as MACRA. And the original purpose of that was to help protect beneficiaries, protect their Social Security. So instead of having to include their Social Security number as part of their information that Medicare receives, that could then potentially find its way onto some sort of black market style data brokering and data mining type situation. It was to assign and make sure that everyone had their own beneficiary number in hopes to just increase privacy and protection. And as often happens, and has been prevalent in South Florida, some individuals have potentially taken advantage of that. So this new statute that was created is specifically targeted to attack and try to prevent the distribution, sale, acquiring, solicitation, anything you can think of across the board as it relates to protected Medicare beneficiary information. And it is a new statute and it is criminal. It is punishable by 10 years.
I understand. And you know, I think it's particularly aggressive because in my view, how else are you supposed to do business? How else are you supposed to market? You know, lead generation has always been part of healthcare for centuries. And so I think that there's going to be probably a lot of litigation around what is acceptable and what is not acceptable. Do you agree, or is this a slam dunk for the government?
No, I do agree. I mean, we just, in the Southern District of Florida, but really in the country, saw in 2023 the first conviction and sentencing for a purely MACRA-related allegation or indictment. And that has to do with a very long time process and sometimes issue in the healthcare arena of lead generation. So, Marissel, lead generation, right? That's always been a problem, right? Getting leads to marketers getting them to maybe from the call center to the data broker to the marketer. That's something we dealt with for a long time. What do you see as potentially different now as it relates to COVID and these testing kits?
Well, I think that always the problem with the leads is when you have bad leads, right? And that's where people get in trouble. You get leads for people that are dead. You get leads for people that are, don't have Medicare anymore, or duplicate leads. And there's a quick way to fix that. And if people are doing their job, which is verifying before they send out the test kits that the person is alive and that they want the test kit, and if they have a recording, I think you have a solid defense, and then you can deal with the list later. I think where people get into trouble is when they're sending test kits to dead people.
Right.
It is my view. And the case that you mentioned, it was particularly egregious, right? What was he doing?
It was. I mean, this individual was on Craigslist, and which is very easy for the government to subpoena, nothing hidden there. And this individual was actively marketing for Medicare information. I mean, that explicit. Mm-hmm. Medicare data, 5,000, and here's how it works. I mean, and that's a market. And some individuals, I mean, I think in everything that we do, there's always an issue of knowledge, intent, right? Do they know? But when there's an individual who is, and we're talking about thousands, hundreds of thousands of leads, and as we've seen, when someone can be very reckless with lead generation from the start, saying that they were calling the person, but they clearly weren't, because we have 1-2 individuals and maybe a call center in most cases that are generating these leads in the first place. The reality that they called 340,000 or more Medicaid or Medicare beneficiaries to actually confirm whether or not they needed an at-home test kit, it's not very likely, right? But it's possible.
Well, in addition to the macro allegations, I think that the other piece of this is the anti-kickback statute. I have seen that, I know the case from 2023 was only a conspiracy, right, to violate macro. Mm-hmm. But I think the other cases we're seeing are going to tack on anti-kickback statute violations and conspiracy charges related to violating the anti-kickback statute. And I believe that those charges are coming because, of course, how are marketers paid and how are people paid for leads, right? They're paying per lead and per test sent.
Yep.
And the government never likes that. Is that what you're seeing as well?
Yeah, absolutely. Absolutely. That's the same kind of theme that we saw with CGX and cancer genetic and then DME. It's all basically, the same attack plan, same theory of prosecution, just different product, you could say. And we know that's how DOJ operates.
Right. And I know we're going to talk about some of the defenses to these allegations a little bit later. Maybe we can talk now about the other COVID test situation going on, which is the COVID testing sites.
Yeah. Tell me about that.
I'll tell you. So what I've seen, it's very similar to the tests that were sent home, except it's also involving the labs, also involving marketers, also involving bad leads. But it also incorporates the testing sites. We all saw tents, all over town, all over the country, really, where people could run in and get a COVID test because you needed a test to fly, you needed a test to go to court, you needed a test for all sorts of things. And now the government has come back around. I mean, we haven't seen these testing sites for years, but the government has now said, no, there's a problem with some of those. And what are the problems? What I've seen is, again, kickback violations, or you didn't send, there was no swabs. You tested for fake patients. The lab never got the test kit and never tested. So there's a little bit of that happening now. I don't know if you've seen the same thing. I'm sure you have.
Mm-hmm. Yeah. No, absolutely. And it's just kind of even on a bigger picture scale, it's just one more example of what we deal with all the time when a emergency happens and a business, okay, if you want to call the lab site a business that does offer a service, it emerges during an emergency, DOJ, automatically, red flag, right? Who's trying to make a buck off of this emergency? And we'll talk about the defenses more, but I have definitely seen it. I have.
Yeah. And now with the testing sites, it's not only anti-kickback violations, right? There's also something else that the government could charge, which is healthcare fraud. So the reason that they can charge healthcare fraud, which is unlike what's happening with the test kits that go home, is because again, medically unnecessary services being provided, right? You didn't need both you didn't need the rapid and the PCR, or you got 3 PCRs in one day. You didn't need all 3. Now, I think there's a lot of defenses to that, because I remember running around, because I had to go to court in the Southern District of New York and running around to 3 testing sites to see who could get me a test fast enough to get me into court. So I think that there has to be a lot of pushback. You just need lawyers to actually fight these charges, because everything was so in flux at the time that all these, different products were out and people were just trying to keep up with the times. I don't know if that's what you've seen.
Yeah. I think, and with in these 2 areas, right? The at-home testing kits and the lab sites, at least in my experience, and all of the defenses that we can talk about and that come into our minds immediately is who is really to say whether a private individual wants to get 5 tests a day, right? You have hundreds of thousands of people dying, okay? Whether you believe it or not, people were dying.
Yes.
This was as big of a crisis as you could possibly have as far as a health emergency in modern times. So somebody wants to go in and ask for 3, whose responsibility is that, right? Is that the individual who's asking for it?
Mm-hmm.
Is it the lab site? I guess the Department of Justice is, correct me if I'm wrong, they're saying the lab site should have been responsible for asking them, have you had one today? Have you had one yesterday? People were terrified.
I'm not sure what the government is thinking, because these are still at the investigation stage,
Mm-hmm.
but you're right. We weren't asked those questions when we went to the testing sites, and I just put myself in. Again, I ran around to lots of testing sites to get tests. Or as you were talking, I was remembering my daughter needed a test to go play soccer, so we would get her tested, and I think this is an area where new law is going to be created, and I'm excited to defend these cases.
Mm-hmm.
And for our audience, can you tell us, David, how does someone know that they're under investigation? What are the signs?
Sure. Primary areas, different ways. Sometimes you get a knock at your door saying, hi, we're with the FBI. I'm John Smith with the FBI, and this is Joe Schmo with HHS, Human Health Services, Office of Inspector General, CMS. We'd like to have a conversation with you about some of your prior practices. Okay, voluntary, they call it, right? And we've had a great success rate, as I'm sure you have too, with our practices of clients who call first.
Right.
Okay, and we hope that happens, but not always, because a majority. For your firm, right? Not to speak for yours, but for ours, and I believe for both, is people who aren't out there, saying, I'm going to go commit fraud today. But
it's scary.
Right.
When an FBI agent knocks on your door, right? People get scared. They want to talk. They absolutely shouldn't, but they feel they need to.
Yeah, absolutely. And so you have that. You have even phone calls sometimes. And I know lawyers like us, we read into these things, and it's so important, and that's why it's so important to hire a lawyer who has that expertise in that area, because if it's a phone call, and whether they left a voicemail or not, mm-hmm. if it's a knock on the door once, if it's twice, all of these things tell us, with our experience, where are they in their case? How interested are they in our potential client and speaking to them? So you see just some attempts at voluntary conversation. Then you see the more aggressive. That's scarier than a letter, but you see target letters in these cases, subpoenas for records, I would say, are the primary ways. Another area, do you agree with those? Are there any others that you could think of? I want to talk also about letters from CMS regarding overpayment, but maybe before, and ask you some questions about that and how to handle those. Before we get into that, what are some ways that you're seeing as far as how these investigations are being initiated?
I think you hit all the target areas, and the only thing all the main points of how an investigation has started. The only thing I'll add is, other than the CMS letters, of course, is sometimes when your bank account gets closed. that is a sign that your bank has received a grand jury subpoena, and that's why they're closing your bank account. If you were involved in the healthcare industry, if you have been involved in selling, COVID test kits, or swabbing people and sending it to a lab, or if you're a lab and your business account or your personal accounts have been closed, you might have an issue. I see that very often, and often clients come to me 6 months later saying, I got a knock on the door, and oh, by the way, yeah, they had closed my bank account 6 months ago.
Yeah.
And I'll just make it to be clear: they close the bank accounts, you get to keep your money. The government's
Right.
not seizing it; it's the bank that doesn't want you there,
Right.
because you've gotten a grand jury subpoena to the bank for your records, because the government always likes to follow the money,
Of course.
right? And you want to tell us a little bit about the target letter? What is that?
Yeah, so in most cases, we see different variations of them depending on who the prosecutor is, who the agent is. Sometimes the letter is a little more aggressive than other times, but in general, you get a letter in the mail that says, you, such and so, our client, are the target of an investigation. Sometimes they list a statute. I think often they'll list a statute. And sometimes the date ranges as well, not always. And even reading into those things, we know how much or how interested, how time sensitive they are. I'm the prosecutor. The agent on the case is so-and-so. Here's our contact information. And in many of them, we see usually the next line after the introduction and what the charges are is that there is a grand jury scheduled for X date. Now, I think we know as experts in that industry and in reviewing these letters that it's a soft date for the most part, not always, and we have to be prepared if that's really when they're intending to go. But there is a grand jury scheduled for this date. If you would like to reach out to us to discuss potential pre-indictment, pre-grand jury resolutions, you need to have your counsel contact us by this date. Or if you don't have counsel, then you need to email us and we'll send you an application, even for court appointed counsel with a target letter very commonly. Mm-hmm. So I'd ask you, Marissel, what's the significance of getting of a target letter versus a subpoena? I mean, what does it really tell you? How do you respond to a target letter?
Well, if one of my clients receives a target letter, I think the stakes are much higher. A subpoena is simply a request for documents or a request to appear for testimony. The government will usually not serve a subpoena on a target of investigation, a subpoena for testimony. Sometimes targets will receive subpoenas to produce documents because the subpoenas go to the company. But once someone receives a target letter, that means that they are the target of a criminal investigation. That means the government is looking to prosecute you and put you in jail. And it's definitely, you're in a danger area. I find that usually the prosecutors send target letters to individuals that they want to come in and cooperate, or individuals that they think will easily come in and speak to them or easily come and plead guilty. And they save the big, production of agents 5 o'clock in the morning arresting you for individuals that they don't give the benefit of a target letter. And so if you're getting a target letter, that's very serious. You definitely need to have an attorney. You shouldn't be communicating with the government at that point about anything because they are looking to put you in prison.
Couldn't agree more.
Yeah.
Couldn't agree more. So this other area that I've seen, and it's not anything new, but as it relates to COVID, I've seen a few times recently that a letter from CMS, a letter from Medicare saying that there has been an overpayment. And often in those letters, the ones that unsurprisingly come around the same time as the knock on the door of the FBI, can be for quite substantial amounts. And they can also commonly, in my experience, and I want to hear your thoughts on it, actually cite or at least give a summary of why there was an overpayment. And sometimes, and often, it says because you submitted either medically unnecessary billing to us, and off the bat, it's like, okay, like how many angles are you going to come from, right? Because you're saying a crime was committed, right? One way or the other. Maybe I want to hear from you. Are there ways to avoid it going further than that? But tell me a bit about what your thoughts are on these CMS letters.
So the overpayment letters, historically, my clients in healthcare receive those letters. The individuals doing the COVID testing sites are not getting those letters because they were being paid by the CARES Act. So thus far, I have not seen any recuperation letters on that end. But on the rapid or the at-home testing, I have seen the letters coming from Medicaid and CMS. The letters, like you mentioned, are actually more descriptive than what you would get from the Department of Justice in a target letter. They're explaining to you why they want the money back, what you did wrong. The problem is that CMS or Medicaid, Medicare is communicating with the Department of Justice. And if you're getting this repayment letter, that means they think you did something wrong. That you probably did something to violate the law. And so you have to be very careful when responding to those letters. Because it usually, whatever you turn over is going to be used against you in a criminal case. So it's almost, you have to tread very carefully, not make any admissions, and certainly hire a lawyer that's familiar with those things before you respond. And also, just because it's coming from CMS and it's not coming from the FBI, OIG, or the Department of Justice does not mean you're not being investigated for a crime. It's just probably a precursor. And sometimes, like you said, it's done at the same time the Department of Justice comes in, but sometimes it's not. Sometimes that letter goes out before you get anything from the Department of Justice. So it's another one of those warning signals, like the bank account closing, that you need to be careful something might be happening.
Right. Absolutely. I can think of one case in particular where over a period of about, maybe it was a short period relative to what it could be, but over a period of about 3 months, my client was receiving pretty regular. This was in a situation where my client was a lab, and they were sending the at-home, they were getting the leads, and they were sending the at-home COVID kits to Medicare or Medicaid beneficiaries. And they would get letters from time to time that said, you submitted this claim to Medicare, we reviewed it, and we found that you were overpaid $124. Please remit. And then they would come. It'd be 124, 184, small numbers over a period of time. And then, boom, the next one, around the time when the DOJ has reached out, we found that you've gotten $100,000 in overpayment, and here are all the reasons we believe so, much more detailed than the others. So I believe that someone who received those letters, even if it's a smaller one, if there's an overpayment issue, contact a lawyer who does healthcare, right? I mean, even if it's for 184, it could be harmless. You might have just, maybe missed a letter, wrong code. One test wasn't fully necessary, and that's okay. There's some room for that, but there might be something more going on.
I can't agree with you more. There definitely could be something brewing. So let's move on to talk about something that I enjoy more, rather than all these bad things the government's doing, defenses to these actions, because there are defenses available.
Yeah.
Can you want to describe one defense possible to these cases?
Sure. I mean, I think as far as the lab goes, and when we talk about defenses, I think some of them apply to everyone, and some of them are more common, whether it's the three main categories: the lab, the marketer, or the lead generator. But I would say, as far as the lab, advice of counsel, right? And if anyone, in my opinion, and I'm sure yours, if anyone is considering starting a lab, they're operating a lab where they are billing federal healthcare, they have to have an attorney doing their contracts. They also have to follow through on the contract. That's a different point we can discuss. But talk to me, in your experience, about advice of counsel. I mean, it's been around for a long time. How are you seeing it being used in these? How have you seen it used generally? If we can talk to our audience a bit about the advice of counsel defense, and then in the COVID lab situation as well.
So I'm gonna just back it up because
Sure.
I didn't explain it probably properly. But when we talk about defenses, we're talking about, okay, you've now been charged with a crime. How is your lawyer going to save you? And these are your defenses. And so, like you said, advice of counsel. Labs. We'll start with labs. Labs have a lot of money when they're starting up because the equipment is expensive and they get paid a lot of money for testing. So they usually have a lawyer that gives them advice. And as long as the lab has followed the lawyer's advice to a T, has shared its complete business model with the lawyer, and there's a solid legal opinion that the lab wrote, and you were getting paid fair market value for your services, you have a solid defense in court. Okay. Now, what I find is always the problem with the advice of counsel defense is sometimes clients don't follow the advice exactly the way that the lawyer gave it, or has not, told the lawyer that they are paying kickbacks to patient recruiters. Those are kind of the bad facts that come up. But a solid opinion from a lawyer can always help. Just be aware that whenever you assert the advice, you are going to have to waive the privilege, which means all your communications with whatever lawyer gave you the advice, you have to, share it with the government because the government gets to attack it. That's how I've seen it work. I have not seen it work in the COVID-19 testing space yet because all these cases are new.
Mm-hmm.
And so far everyone is, people have been pleading guilty or people are still in the investigation stage. I haven't seen anybody litigate it, but I definitely think, people should litigate it if they had a legal opinion because you were probably doing what the lawyer told you to do. And when you follow lawyer's advice, it, negates intent, right? That you were doing something wrong. And I don't know if that's what you've seen in the space.
Yeah, absolutely. I think I agree with everything you said. And it definitely becomes tricky when, and the government loves this, right? Mm-hmm. This is, I think, very common way they overcome advice of counsel is they'll say they did the contract. And even our clients or potential clients that call us and say, we had a lawyer do the contract. Well, then the next big question is, were you performing on the contract? And that's if the government's going to pick it up. That seems to be the most common. The first thing they say, don't talk to me about the contract, whether a lawyer wrote it or not, because it was about what your clients performed. And I don't agree with that, right? Because it's prosecutors see black and white. Okay, we live in the gray as defense attorneys, and we represent human beings, not mugshots. But yes, that is how I'm seeing it as well.
One problem I always have with the advice of counsel defense is the lawyer that wrote the opinion, and you're nodding your head. So why does the lawyer always become a problem? As
lawyers, we worked really, really hard to get where we are. Okay, and to be outstanding members of the bar and to build our firms. And the lawyer's advice on the contract could have been perfect, right? Their advice could have been perfect to the client, but if they didn't operate or follow the lawyer's advice, and two, just more generally speaking, it's scary as an attorney, right? To go and defend. We always want to help our clients, but if advice of, and correct me if I'm wrong, but if advice of counsel is being raised, that means that you're coming in really as a witness, right? You're being forced to waive client privilege with your client if your client raises that, and the privilege does belong to the client, so it's doable, but it's a very uncomfortable thing because this is someone that you fought for in the past, and now you are being put into the public spotlight. Your reputation is on the line, and it's not easy to have a lawyer. You don't want to have to subpoena an attorney, right? And force them to come in. All of us have worked really hard to get to where we are and come into a court. And what you're kind of saying in advice of counsel is that this person who's now being charged with this potentially huge healthcare fraud is saying that they did it because of you. And so I think the lawyers at a certain point, and judges understand, right? That wouldn't be a defense that's commonly used if there wasn't more of a, we understand, we get it, okay? You gave your advice and your advice was sound, but yeah, lawyers, unsurprisingly, are not jumping to be in court and put on the stand.
Of course, and I think it's a problem, unfortunately, for the entire defense of our clients. Their friends don't want to come testify, their employees don't want to come testify. the accountants don't want to come testify, and it's just to overcome this incredible burden of the fear of the federal government. And in reality, usually nothing happens to the witnesses or the accountants or the lawyers. They just come in and they testify, but it's just very scary. So I agree. That's the experience I've had, and I always hate to have to call a lawyer, but sometimes you do because that's your client relied on that. And I've had cases where the government has intimidated lawyers and served them with target letters, and saying, and it's, and we've had to litigate that issue. Like the lawyer is not a target. You're just doing that to suppress statements.
Target letters, it's a bully tactic, no question.
And so you really need lawyers that are going to fight against that, and stand up for the clients, tell the judges this is not okay. The government's bullying them. I think another defense, other than advice of counsel, is some of the clients, like the marketers and the billers, or other people involved in these transactions, didn't have the money to pay for lawyers, but they relied on the advice of the lab's lawyer. Mm-hmm. Have you seen that too?
Absolutely.
Okay.
Absolutely.
And what kind of a defense is that called?
Good faith. Okay. Talk to us, and I would ask you. Tell us about the good faith defense. How have you seen it be used? What is it? How is it used? Pros, cons, pitfalls?
I think that the biggest pitfall with good faith is sometimes the judges won't allow it. There's one particular judge I know in the Southern District of Florida that does not allow a good faith defense, but most judges do. And the good faith defense is essentially that you were acting in good faith. You relied, for example, in our example here, you relied on the advice of the lab's attorney. You read the memo. You relied that the lab owner told you that this was all legal, and you didn't have the criminal intent to commit a crime because you were acting in good faith. Obviously, there's a whole line of cases in the tax arena about good faith. This is a little different, but this is something that really, if especially for the marketers, for example, if you didn't have your own lawyer, but you relied on the lab's lawyer, this is something that you really early on need to latch onto and build a case around it. Because if you were relying on someone else's lawyer, you should be able to raise that. Mm-hmm. Because that is, some kind of indicia of your good faith and not intention to violate the law. That's how I have used it.
And I think just to add on to that, even if a judge in the courts, the federal courts right now might not be accepting that so much as an affirmative defense, like self-defense or like advice of counsel, where we have a burden to put it on, and if the government can't negate it, then it's like a not guilty, right? Or a dismissal in those situations. But even if good faith weren't to arise to a way to just, if we get it done, the case is gone, it still goes directly to the concept that is involved in any criminal defense case, and that we have to deal with all the time, specifically in white collar and healthcare and federal arena, which is intent, right? Even if the judge says, I'm not accepting that as affirmative, valid defense, I'm not going to instruct the jury that they can find our client not guilty if they find that the standards for good faith has been moved. It's certainly, in my experience, still something you can argue and put forth testimony about as it relates to whether your client did have the requisite criminal intent in the case.
Absolutely. Because all these cases, right? That's the number one defense. That the client did not have the intent to break the law. And I think another thing that we should touch on too is all this COVID-19 testing. Everything was new. There was not really. Everyone was moving so quickly. I mean, how quickly did we come up? Did scientists work on to come up with the vaccine? How quickly did they come up with the test? How quickly did we have to get up to speed with testing sites and creating an at-home test kit? So there's so much novelty around all of this that I think that it is going to be hard for the government to prove intent because there was nothing strict, hard and fast about anything having to do with COVID. Everything was moving so fast, unless, of course, you have an open shut case, bad leads, you're selling tests to dead people. I understand that. But I'm talking about the cases on the fringe. I think that there will be, a lot of disruption that lawyers can create in these cases. I don't know if you agree. Agreed.
And I think that's before charges and, of course, after as well. Because I do think prosecutors are rushing into this because they're just like any of the previous big, soup of the day, the big hot button item at DOJ, right? That they decide to, put their strike forces out on, and whether it was sober homes, and then it was, with urinalysis and DME and CGX and now COVID, they're always rushing in. They get an imperative and it's full steam ahead, right? Because again, they see black and white, they don't see humans. And it's our job to explain, look, on paper, right? And in your charts and in your nice grand jury PowerPoint and in your reverse proffer that you showed us, everything looked beautiful. But like at the end of the day, these are human beings, and jurors are human beings, right? You guys aren't the ones making the decision. You can go to your secret grand jury and bring an indictment, sure, because you can put whatever you want in there. But are you going to be able to prove this if you bring this charge when our clients and the mitigating circumstances, how are you going to show that they really had criminal intent, right? So yeah, I agree 100%.
And you said the government's rushing to do this, and I couldn't agree more. Everyone makes mistakes when they rush, and those, the government rushing to bring these cases can only benefit, defendants or people that are being charged and investigated, because if mistakes are made, there's areas and pitfalls and places for us to win. Now, you said the government's rushing, but let's talk about the testing sites, those PCR and rapid testing. That was a couple of years ago. Why are we only seeing cases now?
It's a great question, right? And that's the same. We see that whether it's in the healthcare arena, whether it's in the securities and cryptocurrency, which we'll talk about later. Why are they bringing it now? Backlog, lack of resources, the time that it might take to build a proper investigation and be prepared. Maybe they are working with a marketer because they know they can't get up to the lab just yet. I mean, those are some of the reasons that I see. Prosecutors are lazy, and for the most part. But what do you think about that?
I agree with you 100%.
Yeah.
There's always sometimes there's lag time between the time that the investigation, starts off slow, and then it ramps up, sometime later. And I think that explains the lag time.
It always seems like they're working 5 to 3 years behind in these complex white collar cases for the most part, right? I mean, across the board.
I agree. I think it's 3 to 5 years, and they just need to play catch up. But what does that mean for us as defense lawyers? What do we have to do? Because by the time we get the case, the government's has been working on it for 3 to 5 years.
Absolutely. Yeah, we're playing major catch up, right? And just one more, and if not the most important reason why it's at the very least worth consulting with an attorney like ourselves who specialize in this arena, because we, at least in the Southern District of Florida and in many other districts, we're on a rocket docket here. We're not getting 4 years like they had to get up to speed. The Department of Justice manual itself, from the very top from Washington, says if you bring an indictment, Mr. Prosecutor, what that means is you should be able to go to trial tomorrow. Well, great, they had 4 years to prepare. We can't do that, right? And we see rushed indictments all the time as well. Sometimes maybe because they're getting to the end of the statute of limitations, they haven't met their quotas, underfunding, whatever it might be. But we have a lot of catch up to play. We can do it, and we do it, but it's tough.
I mean, we do it all the time. That's our specialty, and that's what makes us better lawyers than a lot of prosecutors. But it's also why it's so important to get a lawyer signed up as soon as possible.
Absolutely.
When you believe you're being investigated.
Absolutely.
Well, we've been going on for a long time, David.
Yeah.
Do you want to wrap up and give the audience some takeaways from our conversation today?
Yeah, absolutely. I think that really the main takeaways here is if you have any reason to believe that you might have been involved either under investigation or might have maybe just feeling like you read something online or you saw this video and maybe you cut some corners, maybe you submitted some claims to Medicaid or Medicare that were a bit unnecessary. Maybe you submitted more claims. Maybe you got a complaint from Office of Inspector General, or someone just called your lab, and then the lab called you as the marketer, if that's your role, and said, I just got a call from someone who said they got a kit and they're really mad because the person who you sent it to is dead. or I never asked for this, right? Even these little things, they are ramping up big time. They're going to be bringing tons of indictments as it relates to COVID testing, and they're pushing it. We're seeing it. We're defending it. So if you have any reason to believe that you might have any exposure, even if you're confident you don't, just call us, okay? And I'm David Tarras, a partner at the Rawson Law Firm.
I'm Marissel Descalzo. I'm a partner at Taché, Brunis and Descalzo. And I'm going to tell you a little bit about myself because I haven't done that yet. I'm a seasoned white-collar attorney. I've only been a defense attorney my entire career. And I have been defending individuals and corporations against these kinds of charges for quite some time. And David, why don't you tell us a little bit about yourself?
Yeah, so I'm the head of the federal criminal defense practice at the Rawson Law Firm. We're based in South Florida, but we take cases around the country in the federal and white collar investigation arena. We do government investigations, compliance. I like to try cases. That's our thing. We both do,
Yes.
Right? We're trial lawyers at the end of the day. We're creative, and we definitely advise that you reach out to us if you have any concerns whatsoever. We'll sit down with you. We'll walk you through it, and you'll be in a much better place when you finish. So,
And if you want someone who's going to fight for you, that's us.
absolutely. Thank you.